process by which they can force the property to be sold, and I don't want that to constitute a violation.
Real quick, the victim was contacted, and let me just see what the victim's comments reflect. All right. So this is what I'll do. I find probable cause. I'm going to set her bond at $1,000.
Okay.
Make that bond a condition of pretrial release. If she's able to post that bond, she must immediately check in with pretrial, sign up in person, calling that office on Fridays. All the standard conditions plus special conditions 16, 17, and 18. 16 says you do not use, possess, or carry firearms, guns, weapons, ammunition, or knives. 17 says you're not allowed to have any intentional contact with the victim. This means directly, indirectly, or through a third party. You must stay 500 feet away from her home, her vehicle, where she works, or where she goes to school. The exception, Mr. Cato, you're saying is that the mother may act as a go-between just to retrieve items.
Yes, sir. If I could, that the mother, and that she be allowed to take part in any legal process to,
Sure.
in terms of the sale of the home.
Yeah. So
I'll sort all that out. I'll sort all that
right.
out. With the,
yeah, it's a little tricky because I don't know if the alleged victim wants the mother contacting her on. But the reality is, ma'am, you are allowed to go back to that home at least one time within 48 hours of getting out of custody with the police to retrieve any essential items. Now, you can't put your mother up to going to do it, but if your mother wants to retrieve some items from your home, the alleged victim is agreeable to that, then that's certainly permissible. Okay, you just can't use your mom as a go-between to communicate. All right.
No.
That being said, absolutely any court proceedings such as injunction hearings, divorce hearings, criminal court, that's an exception to the no contact provision. Courts always allow, that's the exception. Mr. Kaler, you think we covered everything adequately?
Yeah, I'm just looking with them more. Judge, like I said, if a circuit court has ordered prior to this court, has ordered that this young lady is entitled to be in the home versus, because right now I'm sure the court, did the court check off no return to the event location or simply no contact with the alleged victim?
No, I did 17, which is she cannot have any contact with the victim, must stay 500 feet away from the victim's home. Now, again, if another court has told that alleged victim that your client gets the property and the alleged victim has to go somewhere else, wherever she goes to, your client has to stay 500 feet away. So I'm not trying to do anything to, circumvent or overturn the apple cart of what the circuit judge has done in a conjunction matter.
Yes, sir. That's perfect, judges. If you don't have no return to the event location, then we're in good shape, and I appreciate the court's time.
Yeah, we can certainly, that.
Just don't check that box, judge, and we'll be fine. If the alleged victim is there, she can't go. If a circuit judge told her to get out, then my client can go there, and it's really pretty simple.
Yeah, no, I didn't check the event location. That's what you're saying. I did not check that box.
Got it, Your Honor. Thank you so much. Have a great weekend.
You too. You too.
Your Honor, may I say something?
No, ma'am.
Okay. Perfect.
All right, thank you.
Thank you.
You can just put in there that there's a possible pending injunction. And if the circuit judge has ruled that the victim takes possession of the home or the defendant, then she's allowed, the defendant's given possession by the circuit judge, then she gets to go back to the home. The victim will have to vacate. So it all kind of hinges on what the circuit judge has done.
Perfect, Your Honor. Thank you so much.
You bet, Mr. Taylor. Have a nice weekend.
You do the same.
Any other private attorneys? All right. Folks, we're going to go try to pick up the pace a little bit here. I'm going to do the gentlemen in South County, then the ladies, and then at Central, and finish up with the men in the back. Let's do Kevin Atkinson. Mr. Atkinson, you're charged with domestic violence, aggravated battery. The aggravated is brought about by a pregnant person. Do we have Kevin Atkinson?
He's not here, Judge.
Yeah.
They got him in SPC receiving open, so he's not here.
All right. Yeah, Miss Leatherwood, my assistant we were in limbo contacting the jail to find out where they were, and the jail reported to us that Mr. Atkinson was at South County. You think he might be in transit?
Just give us a second. We'll try to find out where he is, if he's in transit or if he made it here yet, but it's just got SPC receiving open seat. That's all they got.
Yeah, if he's there, we can do his first appearance. If not, we'll just have to, if he's in transit, we'll just set him up for tomorrow morning. So if you could let me know, I'd appreciate it.
Okay, I will.
David Astello.
Estella, put on.
Mr. Astello, you're charged with conspiracy to commit armed robbery and committing robbery with a firearm. Do you want the public defender?
I think I can get an attorney, but I take a public offender. Yeah.
I'll appoint them. State wish to be heard as it relates to probable cause or bonds?
Bond, yeah.
Mr. Astello, I've reviewed your affidavit in my office. I find probable cause. Go right ahead.
Your Honor, based upon this counts being a first degree felony punishable by life, state we are requesting that the defendant be held no bond.
Mr. Astello, having found probable cause on the conspiracy to commit armed robbery, I'm going to set your bond at $15,000. On the charge of committing a robbery with a firearm, that is you want to be heard?
Just that we'd ask for a standard bond, Your Honor.
Okay. On the charge of committing a robbery with a firearm, I'm going to hold you no bond. Bond on the conspiracy will be a condition of pretrial. If you're able to post that bond, you must immediately check in with pretrial release. Sign up in person, calling them on Mondays, Wednesdays, and Fridays. All the standard conditions plus special conditions 16 and 17. You're not allowed to use, possess, or carry firearms, guns, weapons, ammunition, or knives. And you're not allowed to have any intentional contact with a listed victim. This means directly, indirectly, or through a third party. Stay 500 feet away from him, his home, his vehicles, where he works, or where he goes to school. And I also want to do condition 23, you're not to have any contact with any co-defendant directly or indirectly. Step to your left, please.
They step back over there, Estella.
Yeah, I mean, because it's a no bond on this. Dale Brooks. Mr. Brooks, you're charged with failure to register as a failure to register. Information has been filed. Do you want me to appoint the public defender?
Yes, sir.
I'll appoint that office to represent you. Sir, I've find probable cause based upon my review of the affidavit, setting your bond at $5,000 cash or surety. Have a nice day.
Yes, sir.
Daniel Crawford.
Yes, sir.
1,000. Nope. Mr. Crawford, you're charged with felony battery, and you also have a warrantless BOP.
Yes, sir.
Sir, do you want me to appoint the public defender on each of these two charges?
No, sir. I have a lawyer already, Mr. Echemadiaz. So I'm trying to figure out if I can be able to contact him. And also, Jan, I would like to state that the alleged so-called or whatever alleged victim is the one paying my attorney.
Sir, you shouldn't be talking about the case, okay? I just
Yes, sir.
asked you, do you want the public defender?
No, no, sir. No, sir. But
Right.
I was speaking on the part about contact or whatever, because that's the person who is paying for my lawyer.
All right, sir. So I won't appoint the public defender. If you change your mind, you can always ask for them later. I reviewed the paper. Go ahead.
Can the lawyer be given opportunity for this court date?
So you want me to continue your first appearance to tomorrow?
If that is possible, yes, sir.
Yeah, sure. I gave that speech at the beginning telling you as much.
Hey,
That if you
what
want
what
to
is-
postpone it till tomorrow, we can do that. You just got to let me know.
Yes, sir, and, he can do the same thing that other lawyer just did, do it from his office or something like that, right?
I didn't quite follow that, sir. You were saying, can he do what the other lawyer did?
Call into the virtual courtroom. His attorney can call in tomorrow. I think that's what he's asking.
Oh, okay. Yes, sir. Bottom line is if you want to delay this hearing till tomorrow so you can reach out to Mr. Echemendia, you have that right. I'm happy to do that for you.
Yes, sir.
All right, then that's what we'll do. We'll continue this till tomorrow to give Mr. Crawford opportunity to reach out to his attorney to try to have them here tomorrow. We'll see you tomorrow, sir.
All right.
Thomas Dakin,
Yes, Your Honor.
sir, you're charged with 3 VOPs. They're of the warrantless variety. What put you on probation was possession of meth, possession of a controlled substance, and possession of paraphernalia. Do you want the public defender?
Yes, please.
I'll appoint them to represent you. I've looked over the paperwork, finding probable cause, holding you no bond. Are these all out of Volusia County? They're all,
Count as a VOP and then the
So
other
the-
three Volusia.
so the meth is here.
Yes,
The other 2 are VOPs out of Volusia. All right, so you get the public defender on the local charge. You don't get the public defender from this county on the Volusia charges. If you want the public defender on those, you'll have to wait till you get back over there to request that, okay? So you get the public defender on the local possession of meth VOP, finding probable cause, no bonds on each. As long as you're being held on the local VOP, Polk County's not going to call Volusia and tell them to come get you. But once your case here is resolved, Polk will probably send you back to see a judge at first appearance. The judge will probably say, all right, now we'll notify Volusia. They're kind of on the clock to get moving to come get you. And the judge will probably set up a date to come back just so you don't fall through the cracks.
Thank
All
you,
right,
Judge.
so right now, sir, you're being held no bond on all 3, but only one is local charge. Have a great day.
Thank you.
You bet. Next up is Terry Drawdy. Mr. Drawdy, you're charged with 3 offenses: petty theft, resisting without, and then you have a charge of open container, a local ordinance from Lakeland. Do you want the public defender?
Yes, please.
On this one, since the ordinance is kind of part and parcel of the state case, I think.
I believe they're allowed to have the public defender, because I think you can do up to 30 days jail or 60 days jail.
I was gonna say, normally what Ms. Smith would tell me is that, Judge, if it's a standalone appointment, Ms. Cheat would. If it's part of an arrest with state charges, that you guys are involved in that. So, sir, I'm gonna go ahead and appoint the public defender for these 3 charges. I've looked over the paperwork, finding probable cause, setting your bond at 1,000 on the petty theft, 1,000 on the resisting, and 250 on the open container. Have a nice day.
Thank you, sir.
Mr. Cox, remind me who you want to call up?
It's good.
It's Good.
Good. Goode.
Jeslyn Good, or Good, ma'am, you're charged with sexual cyber harassment of another, and you have a VOP that's puts you on probation, was written threats to kill or injure. Does Mr. Cox, she's retained you to represent her?
I have been retained, Judge. I have not filed in on the case yet, but I'll be doing that today or by Monday.
All right.
As to both the VOP and the new charge, Judge. I looked up the new charge, Judge. I haven't come across this as a case of statute. I don't know that the evidence meets the statute, Judge. I believe there has to be more than a showing of what's there. I'm trying to be careful what I say, but according to the definitions, I don't know that they're showing that what she sent was part of that. The other part about it is they're saying it has to be something that be done on social media or sent to another person. It was definitely sent to another person, but it was done to the person whose photos they were. But the only thing that was put on social media is I've got new pictures of you. It doesn't say that there was any pictures or anything put on there on the Facebook page. So it's not reflecting she did any of that. I don't know that it meets the statute, so I challenge the probable cause in this matter.
As luck would have it, I had a jury trial on this charge last week. So I'm somewhat familiar with the standard jury instructions and the elements. Mr. Nakagawa, what says you as far as whether the elements for this charge has been met?
Candidly, Your Honor, and reading the affidavit, I'm a little confused by it as well. It's 24 hours just to see if there's any additional information, if there's potential rewording that could shed some light on the situation.
But Judge, 24 hours put me in Saturday, and I can't be here on Saturday, but we set it over to Monday.
But yeah. Yeah, I mean, I can go ahead and one, the state's asking, and here's the thing, I'm not finding that there's no probable cause, because my reading of it, I mean, I want to give both parties plenty of time to look into it, but there's an and or type of a thing as far as it's social media or sending it to someone else. The allegation here is that she sent it to someone else to, you know, to not be flattering. It was supposed to put the alleged victim in a negative light and to the person that was receiving. So, and then of course there is that social media element where she's posting something, but not the picture. So, but if the state wants to 24 or wants till Monday, I'm happy to do that.
I'd like to see the discovery. I'm not trying to look at the, but I don't know what the picture reflects. I know what the officer says, but the officer doesn't say exactly what the picture reflects. And the picture has to reflect more than just someone who's naked.
I mean, state would argue that the sending of the naked photograph in and of itself is the sexual cyber harassment provided to a third party. Right. Affidavit does make clear that the photo was sent to a third party.
Right.
It
wasn't the person that sent it. It was sent to another person to put it.
I understand, but I'm saying that the way they charge this, if you look at well, we're going to be over till Monday, but I will say this. I believe it doesn't meet the definition of the proper picture for that charge.
The state's asking for more time just to look into it. Sure.
And while he's not, Miss Good, how do you actually pronounce your last name?
Good.
I think we try to make it more complicated than it was.
I did, Judge.
The E kind of threw us.
At this time, Your Honor, based upon reading of the statute as well as the affidavit, I'm going to argue that at this point there is probable cause. We do have an explicit photo being sent to a third party. However, if Your Honor is not finding probable cause, the state will request the 24 hours, which I think defense indicated would be Monday.
Yeah,
Judge, I would ask to give me till Monday. I don't mind being, well, I'd have to do it virtually, Judge.
yeah.
I'm gonna be arguing this case, and it is also a basis for the violation of probation, but it's the only basis for violation of probation.
Yeah, I think there's probable cause, Mr. Cox. Much like her name, I think I'm trying to make it more complicated than it is.
You've never done that, Judge.
There's something that was sent to someone else that was explicit photos involving things, and it was not sent to be flattering, and I don't think it has to be posted. That's just one form. So there is probable cause, candidly. I don't want to make it more complicated than it is. So what I'm going to do is on the warrantless VOP, ma'am, I'm going to hold you no bond. On the sexual cyber harassment, I'm going to set your bond at $2,000 and make it a condition of pretrial release. If you're able to post that bond, you must immediately check in with pretrial, sign up in person, calling that office on Fridays, all the standard conditions, plus the following special conditions. The person who's the alleged victim, whose video was disseminated, you're not allowed to have any intentional contact with them directly, indirectly, or through a third party. Stay 500 feet away from them, their home, their vehicles, where they work or where they go to school. So as far as the third person, you can't tell family members that are friendly with that person to pass along messages. That would be third-party contact and that would be prohibited. Is the state asking for any other conditions? I'm not inclined to do the, no internet or anything like that because she's not accused of posting it on social media. It was, she's accused of sending it to someone else just as a, so I think that's no contact is probably the appropriate thing. Anything else, Mr. Cox?
No, Judge.
All right. Have a great day, ma'am.
I'll be down to
You-
see you, Ms. Good. That's all I had, Judge. My big excuse.
Have a good weekend. No, I did it today. The state was contemplating requesting it. They changed their mind. So there is no Monday. We're just handled it today. Probable cause, no bond on the BOP 2000 as a condition of pretrial on the other. All right. Getting back to where we left off. How about Rafael Gonzalez Colazo? He's another one that shows SPC that I was told would be at South County. Is he also in transit? If so, I'll circle back. That brings us to Caleb Hayes. Might be another one. Caleb Hayes, are you there? That's the third one that says SPC that I was told to be at South County. Jertavion Haynes.
Yes, you're approaching.
Yes, sir.
All right, Mr. Haynes, you're charged with possession of cannabis and possession of drug paraphernalia. Do you want the public defender?
Yes, sir.
Go ahead and point that office. Now, he's a bring back. Is he a bring back? Because he was unavailable or because of a probable cause challenge?
They were saying, I'm sorry, sir.
Say again?
He refused.
He refused to come down.
Yes, sir.
Yeah. It's almost like to help me get ready for court. I wish there's a categories of what type of bring back we're talking about. Sometimes you can kind of connect the dots in your head and speculate, but this was one where I just thought, oh, is this a probable cause challenge, which Ms. Smith certainly will do from time to time on cannabis cases. All right. So, sir, I'll appoint the public defender. Finding probable cause, setting your bond at $1,000 per count. Have a great day, sir.
Yes, sir. So, have a nice day.
You too, sir. William Heath is charged with resisting without violence. Mr. Heath, are you there?
Judge William Heath is in the hospital.
All right. If he's in the hospital, we'll bring him back tomorrow and just check on his status. Moving right along. Next up, we have Elias Ortiz. Mr. Ortiz is charged with introducing contraband into a detention facility. Candidly, I had to look at the statute because I think probably the better description would be possession of contraband in a detention facility, which the statute we always commonly refer to as introduction. Possessing it while in the facility.
In contact with them, so you're already there.
Right. The allegation was he took it from somewhere he shouldn't have taken it, which I had to make me look to make sure it wasn't purely introduction. So, sir, you're charged with that crime. Do you want the public defender?
Yes, sir. Am I being charged with possessive of contraband or introduction?
Now, that's what I was just saying. There's that we call it introduction because that's the one we see most often. But the statute covers that introduction plus possession of it, maintaining possession while you're in a detention facility. The facts of your case, they're not saying you brought it in. They're saying you took possession of it while you were there.
Don't talk about the facts of your case.
Yeah.
So,
Yeah, and just to answer your question, there's more than one way to tackle that allegation pursuant to that statute. So
Yes,
I
sir.
find probable cause, setting your bond at $1,000. Have a great day.
What type of charge is that?
It's a misdemeanor.
All right, yes, sir. Have a great day.
You too. Carlos Perez Barra.
yes, sir.
Sir, you're charged with aggravated battery using a deadly weapon. You want me to appoint the public defender?
Yes, sir.
I'll appoint them. Review the
Yeah.
affidavit, find probable cause. Your bond is set at $15,000, making it a condition of pretrial release. You post that bond, immediately check in with pretrial, sign up in person, call them on Tuesdays and Thursdays, all the standard conditions plus special conditions 16 and 17. You're not allowed to possess or carry weapons, firearms, or ammunition, and you're not allowed to have any intentional contact with the alleged victim. This means directly, indirectly, or through a third party. Stay 500 feet away from them, their home, their vehicles, where they work, or where they go to school. You were starting to say something, sir. Just don't talk about your case, okay?
Okay, I just gonna ask you a question because I wanna I wanna lie detector test because that'll prove my innocence.
Talking about the taxi.
All right,
So I
sir.
want,
Step to your left, sir. That's something you can talk to your lawyer about. Now's not the appropriate time. Have a great day, sir.
thank you too.
You got Elijah Juan Roby. Roby, you're charged with one
That's
count.
not my name, sir. Judge, that's not my name.
All right, sir. Why don't you help me out a little bit if I didn't get it right? Could you please tell me how you pronounce your name?
As a kid, I was taken from the hospital and I was held hostage by a man, and I don't know my real name, but I know my birth parents, and my birth parent, the parents who named me is not my real parents, and it's not my name. I'm being charged, and I'm being accused of all the alleged things. It's not my real name. Like, I'm being here for 2 batteries. I was almost raped, and I was beat by 2 officers and charged with 2 batteries. Like,
All
that's not
right,
my
sir.
name.
You're here having been charged with 5 crimes. They are resisting without violence, 2 counts of resisting with violence, and 2 counts of battery on a police officer. I'll appoint the public defender. I find probable cause. Your bond on the resisting without is $2,000. On each of the 2 resistings with, it's $7,500. On each counts of the battery on a Leo, it's $7,500. Grand
I didn't hear you,
total,
sir. I'm sorry, I didn't hear you.
$17,000. Have a great day, sir. Step to your left.
I didn't hear you, sir.
Have a great day, sir. Step to your left. Your hearing's over.
Right there.
Okay, you are on fire.
Next, sir, next up, we have Darius Saunders.
Yes, Your Honor, I'm here.
Mr. Saunders, you have 1, 2, 3, 4, 5, 6, 7, 8, 9 warrantless VOPs out of Miami-Dade County. Do you want me to appoint? Well, actually, I cannot, sir. You can hire a lawyer if you want, or if you're requesting the public defender, that when you get back to South Florida. I've looked
Well,
over I find probable cause. You'll be held no bond, and we'll notify Miami that they can come get you. If for some reason you're still in our jail a week from today, we'll bring you back so you and a judge can discuss what happens next. Have a
all
great
right.
day.
I was supposed to be here because I was brought back for a week. From
Yes,
the
sir.
last,
Yeah,
I was here last Friday for them to come pick me up in 7 days to be seen by a judge to see why they haven't picked me up today.
yes, sir. I can tell you that having done this job a little while, the warrantless VOPs are the ones that tend to take a little bit longer. And
Nope.
what happens is, unlike someone who has a VOP with a warrant signed by a judge already, and we just happen to arrest you in Polk, but that judge signed the warrant in Dade, this is different. This is where the police charge you with a crime, and the VOPs are warrantless. So it takes a little while for the information to get back to your probation officer down in South Florida, who prepares the paperwork, gets it in front of a judge down there. That judge will sign it, and then it gets sent back up here. And the jail down there now knows they're free to come get you.
All right, no, Judge. Last week I came Friday. It was
No,
put
I
in
know,
for-
I understand all of that, but what do
It
you,
was-
what do you?
A
what
warrant
do you-
was
what do you
put
want
out.
to do?
A warrant was put out for me from Miami-Dade, and the judge told me that if Miami doesn't come and pick me up in 7 days, I would be here today, which is the 13th, for a release
Sure.
on our.
If
for
you
our-
heard what I told that last gentleman, or I was about to tell you, is that you can come back and talk it over with the judge, but there's no guarantee that that judge is going to let you out. I've been known to, on certain types of cases, to give you a release date from the jail if they haven't come to get you. But on this one, I'm choosing not to do that because candidly, you got 9 felony charges out of South Florida. And the allegations are such that I think it's prudent to just let you sit there for a little longer.
I was only driving with license suspended. That's why I was arrested.
Not
And I
talking
can't-
about the facts of your case right now. You just admitted to it. Stop talking.
No, I'm saying that's what I was charged with.
Okay.
last Friday, the judge told me if Miami didn't come and pick me up in 7 days, that I would be released.
Well, that judge isn't here today, sir, and I'm not going to do that. So we'll bring you back next Friday. Have a great day. If you're still here. And gentlemen, a lot of people are wanting to talk today, and I really try real hard to be a patient judge. But when you guys talk, it's just now's not the time to do that. Everybody wants to say things and to try to convince me to let them out of jail. When you say things, many times you shoot yourself in the foot. So the best practice, as I said at the beginning, we're recording everything. So please don't talk about the facts of your case. And I'll try not to give you an opportunity to say more than you should be saying. I'm going to go through those 4 things, like I said, and we'll keep it moving. Next up is Alfonso Sargent, Guy Alfonso Sargent.
Yes.
Sir, you're charged with failing to appear for court on charges of aggravated trespass. Do you want me to appoint the public defender?
Yes.
I'll appoint them, finding probable cause, holding you at $2,000. Have a great day, sir.
Okay.
That brings us to William Siegel.
Yes, sir.
Mr. Siegel, you're charged with knowingly giving false information to a police officer involving an alleged criminal event. Do you want the public defender?
Yes, sir.
I'll appoint him. I've looked over your paperwork, finding probable cause, setting your bond at $5,000. Have a great day. Next up is Daniel Smiley.
Present.
Mr. Smiley, you have 4 charges. They are burglary of a structure, criminal mischief, possession of burglary tools, and grand theft of property greater than $750. Do you want the public? And let me just say this, all of your charges have been upgraded because the allegation is you wore a mask during the commission of those charges. Do you want the public defender?
Yes, sir.
Appoint them to represent you. Sir, I've read the affidavit, finding probable cause, setting your bond at $15,000 on each of these 4 F2s, making those bonds conditions of pretrial release. If you post bonds, you must immediately check in with pretrial, sign up in person, calling them on Tuesdays and Thursdays, all the standard conditions, plus special conditions 17 and 21. 17 says you can't have any intentional contact with the listed victim. Of course, that's a business, so you must stay 500 feet away from that business. Also, 21 kind of covers the same base. It says you must stay 500 feet away from the event location, which is the business. I'm sorry, go right ahead.
Your Honor, was there any paperwork that alleged the enhancement?
Yeah.
There was, okay.
Yeah.
I just might have missed it, okay.
Yeah, I can go back and pull it up. I have it right here.
I just wanted to make sure that there was something, because if there was, I believe, Your Honor, I just wanted to make sure that there was something reflecting.
Yeah, and I have Mr. Smiley right here. The first thing that tipped me off is everything's an F2 on the affidavit. And
Your Honor, they forgot this.
yeah, I was gonna say, yeah, so that, and the very first, it looks like and I agree with you, sometimes the deputies don't do it, or the officers don't do a very good job. This one, the very first paragraph was, gives me the statute number of 7750845.
I think I just see past that.
Understand. All right, have a great day, sir.
Thank you.
That's. Next up is John Spiney, or Spine. He might be another one that's in transit.
Yes, Judge, he's supposed to be on his way up there. We called and got in touch with him. They said they bringing him up, so.
All right, so there's a handful of them that was kind of in limbo, so we'll try to call them before, let me know when we're done with everybody else at South County.
Okay, we got Gonzalez and Atkinson.
Okay, 1 second, I'll circle back. Dylan Tarleton.
He didn't come up for medical reasons. I can tell you what it is if you want me to.
Well, no, I mean, so he's not available. He's being treated for something medical.
Yes.
I'm going to bring you back tomorrow. All right. Well, thank you for that information, sir. We'll bring him back tomorrow. And all right, that's everybody that I had. Now, you said you have 2 that we've already covered. Have one of them come on up and tell me his name.
Step on up there, Atkinson.
Kevin Atkinson is charged with domestic violence, aggravated battery on a pregnant victim. Sir, do you want me to appoint the public defender?
Yes.
Appoint him. Looked over your paperwork, finding probable cause, setting your bond at $5,000, making it a condition of pretrial release. If you post that bond, you must immediately check in with pretrial, sign up in person, calling them on Fridays, all the standard conditions plus special conditions 16 and 17. You're not allowed to have in your possession weapons, firearms, or ammunition, and you're not allowed to have any intentional contact with the victim. This means directly, indirectly, or through a third party. Stay 500 feet away from her home, her vehicles, where she works, or where she goes to school. Have a great
Well,
day.
we
sir.
have kids together.
Yes, sir. I know. I didn't tell you not to have contact with your kid. I said no contact with her.
And if you get bond out, you can talk to your attorney about getting that modified, okay?
Okay, because that's what I'm gonna do. I just want to know where I can still see my kid.
Yes, sir. It's tricky. I'm not going to pretend like it's not. You can't have contact with her, but I'm not trying to pretend like I'm a divorce judge or a custody judge. That's another matter. I'm just saying you can't have contact with her. Have a great day.
Yep. That's fine with me.
All right, this next gentleman, if you don't mind, tell me his name.
That's Gonzalez, Raphael Jr.
All right, Rafael Gonzalez Colazo Jr., charged with domestic battery. Sir, do you want the public defender?
See, yes.
I'll appoint them to represent you. Mr. Gonzalez, are you able to understand English? If not, we'll have to bring you back tomorrow.
No, I understand a little bit English.
Okay, I just want to make sure you were following me. It seems like you are.
Yes,
So,
sir.
sir, you're charged with domestic battery. I'll appoint the public defender. I reviewed the paperwork back before court, finding probable cause, setting your bond at $5,000, making it a condition of pretrial release. If you post bond, you must immediately check in with that office, sign up in person, call them on Fridays, all the standard conditions plus 16, 17, and 18. You cannot use or possess firearms, weapons, or ammunition. You can have no contact with the victim directly, indirectly, or through a third party. Stay 500 feet away from the victim as well as the victim's home, vehicles, where she works, or where she goes to school. And because you lived with the victim prior to being arrested, you will get to go back there one time if you choose to within 48 hours of getting out of jail, but you have to be accompanied by the police when you go there to get your essential items like medicine and clothing. Have a nice day, sir.
You too, sir. Thank you.
Judge Spinney, John Spinney.
All right. And Mr. Spinney,
Yes, sir.
you are charged with domestic battery. Do you want me to appoint the public defender's office to represent you on this charge?
Yes, sir.
I will do just that. I have reviewed your paperwork back before court, finding probable cause, setting your bond at $5,000. If you post that bond, you must check in immediately with pretrial release, sign up in person, calling them on Fridays. All the standard conditions plus the following special conditions. You cannot have weapons, firearms, or ammunition in your possession. You can have no intentional contact with the victim. Stay 500 feet away from the victim as well as the victim's home, vehicles, place of employment, and school they attend. And because she resided with the victim prior to being arrested, you get to go back there one time if you choose within the first 48 hours after getting out of jail. But to do that, you have to be accompanied by the police. The purpose of going to that home is to retrieve essentials like medicine and clothing. Have a nice day, sir. And the last gentleman, is that Mr. Hayes?
Yeah, Taylor Hayes.
Mr. Hayes, you're charged with domestic battery. You want me to appoint the public defender to represent you?
Yes.
Mr. Hayes, I'll do just that. I have reviewed your paperwork back in my office. I do find probable cause for the charge. I'm going to set your bond at $5,000 and make it a condition of pretrial release. If you're able to post that bond, you must immediately check in with and sign up in person with the Office of Pretrial Release. Call them on Fridays while your case is pending in the criminal system. You have all the standard conditions plus the following special conditions. You are not allowed to be in possession of nor can you consume any alcohol. You can't go to any bars, nightclubs, or lounges. You'll be subject to random urinalysis for breath. You have, you're not allowed to have in your possession any weapons, firearms, ammunition, or knives. You can't have any intentional contact with the listed victim. This means directly, indirectly, or through a third party. Stay 500 feet away from the victim as well as the victim's home, vehicles, place of employment, and school they may attend. And because you resided with the victim before your arrest, you get to go back one time within 48 hours, accompanied by the police to retrieve your essentials like medicine and clothing. Good luck to you, sir.
That's it, Judge.
Thank you, Deputy. I appreciate all your help today. Have a great weekend. Moving on to the ladies. First up, we have just so cover our bases for everybody else. Leah Bass bonded. We've already done Maya Bass. Barbara Busby bonded. Wanda Butler bonded. We've already done Claudia Capillo Hernandez. Catherine Cantrell bonded. We've already done Maria Cardona Castillo. We've done Adelise Mar Castro Leon. So that brings us to Crystal Collins. Miss Crystal Collins, are you there? Miss Collins, you're charged with 4 things. They are possession of paraphernalia, possession of cocaine, introduction of contraband into a detention facility, and tampering with physical evidence. Do you want me to appoint the public defender?
Yes, sir.
Hey, I'll do just that. Ma'am, I've read your affidavit back in my office. I find probable cause for these 4 charges. I'm going to set your bond at $1,000 on the paraphernalia, $5,000 on the cocaine, $5,000 on the introduction of contraband, and $5,000 on the tampering with physical evidence. Have a nice day. Brings us to Jennifer Flott. Jennifer Flott has 8 charges. They are 1 count of all 8 of them. Okay. Ma'am, do you want the public defender appointed to represent you?
Yes, sir.
All right. I'll appoint that office to represent you. I reviewed the affidavit back in my office. I find probable cause for all 8 charges. Just so you know, 7 of the 8 is a misdemeanor of the 1st degree. The 8th charge is a 3rd degree felony. So having found probable cause, I'm going to set your bond on the 7 misdemeanors at $1,000 per count. And on the 1 3rd degree felony, I'll set your bond at $5,000. I'm going to make those bonds conditions of pretrial release. If you're able to post those bonds, you must immediately check in with the Office of Pretrial Release. Sign up in person, calling them on Fridays. All the standard conditions. Is the state requesting any special conditions?
What's your honor, special conditions? Says any.
Ma'am, I think that's fair. So all the standard conditions and the special condition number 27 is you're not allowed to have any contact with or be in possession of any animals. Have a nice day. Krista Geddes. Miss Geddes, you're charged with battery, domestic violence. Do you want the public defender?
Yeah.
I'll appoint them. I reviewed the affidavit. Go ahead.
I heard that he had dropped charges. Would there be anything to do with it if he drops charges? I don't know anything about this, so I heard that he had dropped charges before I even got booked in.
Yes, ma'am. That's something between him and the state attorney. The state attorney is the one that would bring formal charges. So he didn't sue you, the alleged victim. The state's the one that would be bringing charges. He has every right to go let the state know what he wants them to do, but it's the state attorney that makes that ultimate decision. So ma'am, you're charged with domestic battery. I'll appoint the public defender, finding probable cause, setting your bond at $2,500, making it a condition of pretrial release. If you're able to post that bond, you must immediately check in with the Office of Pretrial Release, sign up in person, call them on Fridays, all the standard conditions. Victim contact sheet in this one? So special conditions 16 and 17, and on the affidavit, does it show the same address?
Yes, he lives with me.
Okay, okay, so same as I've been giving other folks. 16 says you can't have weapons or firearms in your possession. 17 says you can't have contact with him. Stay 500 feet away from him, his home, his vehicles, where he works, or where he goes to school. But because you lived with him before you got arrested, you do get to go back one time to get your stuff, but you have to have the police go along with you, and that
So that
has to
means-
take place within 48 hours.
Right now, Your Honor.
So he lives at my mother's house with me. So that means I get kicked out of my own house?
Let's talk about the facts of your
What?
case. Right now. Ma'am.
What were you having to say?
Would you consider no violent contact, Your Honor?
Has there been, I've read it all, but let me take a quick look. Had he requested the contact, I would, but I don't feel comfortable. He called 911, made the allegations. The pretrial reached out, they couldn't get a hold of him. So ma'am,
Oh,
look,
you
I'm,
couldn't?
say
You
again,
could not, you said you could not get a hold of him?
I didn't try to call him, ma'am. So,
I can give you a number to try to get a hold of him.
no, ma'am, I'm not doing that. Pretrial
Okay.
has a role, okay?
Okay.
I think for now your hearing's over. You can always take it up with the judge assigned to your case. Have a great day. Next up, we have Lacey LaFave. Ms. LaFave, you're charged with domestic violence battery. You want me to appoint the public defender?
I have an attorney that will be representing me, but yeah, public defender, I'll take it.
That's what you want me to do. I'm happy to provisionally appoint them to represent you. So I'll provisionally appoint them. Ma'am, I've looked over your affidavit back in my office. I find probable cause, setting your bond at 5,000, making it a condition of pretrial release. If you post that bond, check in with pretrial right away, sign up with them in person, calling them on Fridays, all the standard conditions plus special conditions, 16 and 17, which says you can't have weapons, firearms, or ammunition in your possession, and you can't have any intentional contact with the alleged victim. Stay 500 feet away from the victim, their home, their vehicles, where they work, or where they go to school. Have a nice day. Dorothy Lambright. Ms. Lambright's charged with possession of meth and possession of paraphernalia. Ma'am, do you want the public defender?
Yes, sir.
I'll appoint them. I've looked over the affidavit, finding probable cause, setting your bond at 5,000 on the meth, 1,000 on the paraphernalia. Have a nice day. Lisbeth Lorenzo is charged with a warrant out of Palm Beach County for a VOP. Ma'am, I can't appoint a public defender here for a Palm Beach County VOP. You can always hire a lawyer now or wait till you get back there and ask for the public defender. I find probable cause, holding you no bond. If nothing is keeping you in our jail other than this charge, Polk will call them and tell them to come get you. Many times they come quickly. Sometimes with warrantless VOPs, they take a little longer. This one does appear to be a warrant. It came out of them, so I suspect they'll be up here quicker because it's not the latter category. If for some reason you're still here, we'll bring you back a week from today to talk it over with the judge. Have a nice day. Holly McDuffie. Ms. McDuffie, looks like you were a bring back. Was that because she was unavailable yesterday? Wasn't anything to do with the documentation, I don't gather?
It was because I went to the regular court earlier this morning. I was supposed to be with Miss Pinkett, I think her name was, at 9 o'clock. And
Right.
I went there and I got back here about 11:30 after lunch, and they said that they wanted to postpone it till Tuesday. Then when I went back right there, they brought me back right here. So
Yeah.
I don't know, sir.
Well, we're gonna hear it before.
I just know I'm here on a Marchman Act. That's it.
This letter would just call it, said it was a bring back. So I was just more worried about yesterday's first appearance.
Yes, sir.
I mean, so she was scheduled yesterday, and so why did she get brought back today?
She was in court yesterday, Judge,
And today.
and they brought her back
Wasn't-
to
So she just wasn't available. That's all. That's really the gist, because I wanted, if it was probable cause, I'm gonna turn to you guys and say, well, what have y'all come up with? But if it's an unavailability, that's what I was saying earlier. I wish there was a different term we could use for bring back, because bring back means a lot of different stuff. In this case, she wasn't available. Okay, that's different than judge, there's no probable cause. I'll give the state 24 hours. So ma'am, you weren't available. Now you are. I'm looking at a writ of bodily attachment. You're right. Her name's,
What, hold on, you said I wasn't available when? Cause I've been here since Wednesday. I went to court yesterday.
That's what he's talking about.
Oh, okay, okay, I'm sorry.
Yeah.
The judge wasn't available. Okay.
no, ma'am. No, ma'am. Some judge sat in my chair yesterday, and for whatever reason, you couldn't be brought to first appearance yesterday. Maybe it was because you were over here at the courthouse. I'm just telling you,
Yes, sir.
they put you back on today, and all I have for information was, because I wasn't here, is that you were being brought back because you weren't able to be handled yesterday.
Yes, sir.
Here on a writ of bodily attachment, I find probable cause because it has Judge Pinkett. She does the F8 division that does with drug court and various other specialty courts. She basically says that you're going to be held in custody until you can be brought before the judge as soon as possible. I think she does courts on Tuesdays.
Especially set for the Tuesday morning at 9 for PAC and 7 o'clock.
There you go. You'll go see her for the drug court docket next Tuesday. Have a great day, ma'am.
Thank you.
Yeah. Pamela Mefford. Ma'am, you're charged with simple battery. Do you want the public defender?
Yes, sir.
I'll point them to represent you. Ms. Mefford, having found probable cause, I'll set your bond. Oh, find probable cause, you have a notice to appear. That's not something I could take you into custody, no bond on. And I'm going to factor that in, that you got a couple open cases and you're being accused of a new crime. So I'm going to set your bond at $2,000, making it a condition of pretrial release. If you post that bond, you must check in with pretrial, sign up in person, calling them on Fridays. All the standard conditions plus special conditions 16 and 17, which says you can't have weapons, firearms, or ammunition in your possession, and you can't have any intentional contact with the victim. Stay 500 feet away from the victim, their home, their vehicles, where they work, or where they go to school. Step to your left, ma'am. Have a great day. Marcasia Lanice Medalis. Ma'am, you're charged with possession of marijuana, possession of drug paraphernalia, and 2 counts of contributing to the delinquency of a minor. Do you want the public defender?
Yes, sir.
I'll appoint that office to represent you. Would you like to be heard on probable cause or bonds or both?
Probable cause in regards.
Both, please.
Probable cause in regards to the charge to cause the child to be delinquent or dependent. So is this contributing to the delinquency of minors and it was just written differently than typical?
What do you mean? Like,
I have the charge written as cause child to be delinquent.
yeah, it's contributing. I mean,
Okay.
it's all under, that's one of the struggles at first appearances is the terminology that pops up on this document or the clerks, and the affidavit sometimes is just slightly different. But yeah, I interpret it as that she was in a vehicle smoking marijuana with a couple of minors is how I interpreted that, is how they contributed.
I think the probable cause that a little bit differently. I didn't see any allegation that there was active smoking witness. I just saw that afterwards they searched her purse and found marijuana on her. So I don't think that carrying marijuana, ma'am. I don't think that carrying marijuana and then being found with the marijuana, just because children are necessarily present, rises to the level of contributing to the delinquency of minors. Now, if they would have been found and it was alleged that they were actively in the process of smoking, or smoke was coming out of the vehicle as they opened the doors, but I believe all I saw was that marijuana was found in her purse after the initial traffic stop.
Okay.
I didn't see any witnessing of the smoking or anything that would allege that the smoking just had recently taken place.
I mean,
The affidavit does say that the officer did detect a strong odor of cannabis coming from the vehicle.
But that could be from just the presence of the cannabis. It didn't say freshly smoked from what I read, which is often terminology you do see differentiating between having just used and being found in possession of. I think there's a distinction for this purpose of this charge. I'm sorry if I did.
Any response from the state?
Also point out, Your Honor, that there was also marijuana not found in the marijuana from the vehicle itself. So you couple them.
I think it's a pretty good argument, you know. I don't think there's probable cause for the contributing. If you want 24, I don't know if there's any more information to be had, but if you want to ask for 24 hours, I'd bring you back tomorrow morning. I'm set her bond at 1,000 on the other two, and at the end of the day, the state makes the final decision as to whether they charge her or not on the contributing, and then that becomes more of a JOA sufficiency of the evidence type of analysis down the road. But
I think at this point, Your Honor, I think the affidavit, there's a lot of detail in the affidavit. If there's fresh smoke coming in, I think Rex would have noted that.
Yeah. That's kind of what I was thinking. That would be the obvious. I think that's why the argument is what it is. I mean, if it's billowing out when the doors open, then that's a whole lot stronger case that they were all in there. So I'm going to, ma'am, on the contributing to the delinquency of a minor, I'm going to ROR you, finding no probable cause. Again, you're not out of the woods yet. The state gets the final say so on whether or not they do any research or investigation and decide to charge you with those crimes, but you'll just be ROR on those two. The other two charges, your bonds are 1,000 apiece. Have a great day.
Thank you so much.
Have a nice day. Maria Miranda Lopez. Ma'am, you're charged with battery on a police officer and trespassing. Do you want the public defender?
Yes.
I'll appoint them to represent you. I've looked over the paperwork, finding probable cause, $5,000 bond on the battery on a Leo, 1,000 on the trespass. Have a nice day. Gina Rea. Ma'am, you're charged with aggravated battery on a person 65 years of age or older. You want me to appoint the public defender?
Yes, sir.
All right, I'll go ahead and appoint that office to represent you. I've looked over the paperwork. I find probable cause. See what the state has to say about bonds.
Your Honor.
Sure.
Your Honor, this is a motion for pretrial detention. Copy has been provided to defense. Your Honor finds this motion to be facially and legally sufficient. State would request a pretrial detention hearing to be set for Thursday, March 19th at 1 p.m. on the A2 docket.
Anything from the defense?
It appears that it's a facially sufficient motion. Just seems like this is exactly the person.
Ma'am, I've got a document in front of me. It's 2 pages in length. It's titled Motion for Pretrial Detention, and it's filed pursuant to Florida Rule of Criminal Procedure 3.132 and Florida Statute 907.0415D. I do find that it's on its face, it's legally sufficient. And so as a result of that, I'm going to hold you no bond on this charge, which qualifies under that law. And we'll hold you no bond until you go see a judge on the 19th, which is about 6 days away. And that's what we call the A2 circuit judge. And you'll have a hearing at that time. Okay. Have a nice day, ma'am.
Thank you.
Next up, we have Monique Shaw. Ms. Shaw, you have a warrant out of Orange County for failing to appear on a charge of petty theft. I cannot appoint the public defender, but you can always ask for, hire one or ask for the public defender when you get back to Orlando. Find there's probable cause from the paperwork provided. Your bond has been set by the judge over there at $1,000. Have a nice day, ma'am.
Thank you.
Vargas is already bonded out. Mary Vargas. That brings us to Chiffon Wick or Wiki.
Like,
Like, kind of like pipe, but like. Miss Wyke, you're charged with, by information, which is a formal charging document from the state. You're charged with felony petty theft. Looks to be two separate charges. The felony is based upon 2 or more prior convictions for theft. Do you want me to appoint the public defender to represent you?
yes, sir.
I'll
What was
appoint
the
that
first
off.
thing you said I'm charged with?
Say again?
What was
Sure.
the first thing you said I'm charged with?
You're charged with 2 counts by information with felony petty theft.
Oh, okay. Yes, sir.
Yeah, so the state's filed the formal charging document. Felony petty theft times 2.
Okay.
Looks like you might already have Miss Meeks. Does that sound familiar?
Yes, sir.
No.
But I don't have her. I don't have her on these 2 new charges. And I don't know if my family can afford to add these 2 on or not.
She's filed a notice of appearance, same case number that she's filed a notice of appearance on.
So these
Oh, no, that's case number.
2157 is these case numbers.
Okay, yes, sir. Yes, sir. Filed a notice of appearance.
Yes, ma'am. So these are, sometimes the state can add charges, meaning
Yes, sir.
you've already come to first appearance, probably already arrested. She might have got hired for that, but the state, when the dust settled, they filed these additional charges.
Yes, sir.
So Miss Meeks has apparently filed a notice of appearance saying she's representing you. But again, if something goes south and she quits representing you, you can always ask for the public defender at that time.
Okay, thank you.
I find probable cause. Your bond on these 2 third-degree felonies is $5,000 per count. There'll be a condition of pretrial release. If you're able to post those bonds, you must sign up with pretrial in person right away. All the standard conditions. Does she already have a call-in? Calling in on Mondays. You have all the standard conditions plus special condition 15, which is a 7 p.m. to 6 a.m. curfew. You also have 17, which has no contact with the victims. You have 21, which says stay 500 feet away from the event location. And lastly, you have to have no contact with the co-defendants. Have a nice day, ma'am.
You too, sir.
Thank you. On to the gentleman. First up, we have Joshua Aguiar, charged with violation of his community control on a charge of shooting into an occupied vehicle. Sir, do you want the public defender for this violation of community control?
No, sir.
Okay, if you change your mind, you can always ask later. I'll find probable cause because I'm looking at Judge Denmark's warrant. Going to hold you no bond and we'll send you to see her on April the 7th. Have a great day. Charles Bogan. Mr. Bogan, you're charged with domestic battery by strangulation. Do you want the public defender?
Yeah, yes, sir.
Appoint them to represent you. Sir, I've reviewed the paperwork, finding probable cause. Your bond is $5,000. It's a condition of pretrial release. If you post bond, sign up with them in person, calling them on Fridays, all the standard conditions, plus special conditions 16, 17, and 18, which is you can't possess weapons, firearms, or ammunition. No contact with the listed victims. Stay 500 feet away from the victim, their home, their vehicles, where they work or where they go to school. And because you shared a home prior to being arrested, you get to go back there one time with the police within 48 hours to get your stuff. Have a great day.
Judge, we skipped Aguilar?
No, I just did Mr. Aguiar. Yeah, he was the one right before. Yeah.
I mean, I know one, but I have to make sure he was.
Yeah, Mr. Aguiar stood up there and we did his violation of community control. He said he didn't want the public defender. I found probable cause and told him he's being held no bond based
Okay,
upon
gotcha.
Judge Denmark's warrant. All right, moving right along. I think we're up to Alexander Camacho. Mr. Camacho, you have a local new charge of attempted burglary and you have a warrantless VOP out of Orange County. On the local charge, do you want the public defender?
Yes, sir.
I'll appoint them.
Yes, for me to conduct all caused in the new law charge, which I think was the only basis for the violation of probation, but that would be for Orange County. In regards to the attempted burglary, there wasn't any evidence of what crime he attempted to commit once he was inside. If they wanted to charge an attempted trespass, I think that would be more appropriate. He was seen jiggling on the door and told to leave by the homeowner. She said he just stood there, and then she called the police. The police got there. He said he thought he was looking for his girlfriend's house. See what crime he attempted to commit once he would have gotten into the house, or what evidence of any crime there is. In fact, if he was going to commit a crime, the homeowner even opened up the door and was standing right there for him to do whatever he was going to do, and he just stood there for law enforcement to arrive.
I've always thought this is a peculiar area of the law, and that's why the case law talks, or I mean, the jury instructions talks in terms of, did he, because the intent is the function of the mind. So you basically is heavily reliant on circumstantial evidence. That's why they give you case law / jury instructions that talk about, did he enter surreptitiously? Was he sneaking around? Was he doing certain things? So to his point, he's opening the front door and the lady comes out. So it's not exactly a cat burglar hiding in the shadows kind of thing. So, but at the same time, the allegation is he's going to a front door of a home.
And I would point out, probably this is somewhat analogous to, people going and pulling on car handles, saying.
Yeah, I guess it is very similar. And I guess,
But he did provide a reasonable explanation. I actually drive the state car to watch all the time. It's a silver Chevy. I walked into the parking lot and yanked on the wrong silver Chevy's door. And if somebody asked me why, it would look like I was doing that. And then I provided an explanation. I have a silver Chevy. It's 7 cars down. I very much apologize. I don't think there's anything here that alleges he was attempting to commit a crime.
So you would agree though, with if I found him probable cause for the attempted burglary or probable cause for the attempted trespass, either way, it's the basis for a VOP.
Yes, I would understand the basis for attempted trespass.
I totally agree with you about that car handles. I guess the quantity, usually is the telltale. It wasn't done accidentally when you're walking down the street in a neighborhood, pulling every door handle, trying to find some that's open. That shows you the intent was to steal stuff. Here, I guess the defense potentially could be, it was an accident. I went to the wrong door.
And he even provided that explanation of, I'm looking for my girlfriend.
Okay. Yeah, I think it's a good argument for this stage of the case. Again, it's ultimately your decision to state. So if you want 24 hours, I can give it to you. I think that, I don't know if there's any more evidence to it that you can come up with, but I'll find probable cause for attempted trespass. That will, and again, you can do your own research or investigation, decide how you want to file it. All right, sir. So I think the argument from the defense is well taken. I'm going to find no probable cause for attempted burglary, but there is probable cause for attempted trespass. That's attempted trespass it'd be of a convey or a structure. So that would be an M2. Yeah. Either way, it's an M2. So on that, I'm going to set your bond at $500. I think that's probably reasonable. But the more important matter is it's going to be a violation of your probation, the warrantless VOP. So I'm going to hold you no bond on the Orange County VOP and set your bond at $500 on the PC for the attempted trespass. All right. If you're, as long as you're being held on that local charge, we're not going to call, we being Polk County, are not going to call Orange County and say, come get you. But if you resolve the local charge or you bond out, then they'll call them and say, come get him. you'll probably be brought back to see a judge so we can just address that so you don't fall through the cracks and give you a court date to come back. Have a great day, sir.
All right, thank you, sir.
You bet. William Campbell is charged with possession of fentanyl, possession of paraphernalia, a second charge of possession of paraphernalia.
Still.
Do you want the public defender, sir?
Yes.
And he's shaking his head, yes, I'll appoint them. Finding probable cause, setting your bond at 5,000 on the fentanyl, 1,000 on each of the two paraphernalias. Have a great day, sir. John Cecere is charged with possession of meth, possession of paraphernalia, and violation of an injunction for protection against domestic violence. Do you want the public defender?
Yes, sir.
I'll appoint them. Finding probable cause, setting your bond at 1,000 on the paraphernalia, 1,000 on the DV injunction, and 5,000 on the methamphetamine. Those bonds are going to be conditions of pretrial release. If you're able to post those bonds, you must check in with the Office of Pretrial Release. Immediately sign up in person, calling them on Fridays, all the standard conditions, plus the following special conditions. You're going to have to abide by any injunction that's currently in effect, and you're not allowed to have any intentional contact with a listed victim. This means directly, indirectly, or through a third party. Stay 500 feet away from them, their home, their vehicles, where they work, or where they go to school. Have a great day, sir. Carlos Chalice Medina, you bet. Carlos Chalice is charged with resisting without and domestic battery by strangulation. That strangulation makes it a felony. Sir, do you want the public defender?
Yes, sir.
I'll appoint the public defender to represent you. Sir, I've looked over the paperwork, finding probable cause, setting your bond at 1,000 on the resisting, 5,000 on the domestic battery, bless you. Those bonds are going to be conditions of pretrial release. If you post that bond, those bonds, you must immediately check in with pretrial, sign up in person, calling them on Fridays, all the standard conditions plus special conditions 16, 17, and 18, which says no weapons or firearms or ammunition can be possessed, no intentional contact with the listed victim, stay 500 feet away from the victim, their home, their vehicles, where they work, or where they go to school. And since you resided with the victim prior to being arrested, you get to return there one time with the police within 48 hours to get your stuff like medicine and clothing. Have a great day. Devontae Davis is charged with burglary of a structure or conveyance and petty theft. Sir, do you want the public defender?
Yes, my charges are wrong. I think I was only charged with petty theft because of the other stuff was not felt the evidence. The detective did detective work. He searched my room and caught and found no evidence.
The facts of your case. That's not what this is for. You're hurting yourself. Ron, we'd like to contest the probable cause, the burglary charge.
Okay.
Basically, they were living out of shared rental, essentially. And it was alleged to have gone into the room of the other and taken. I don't think that when you're sharing a home, doors are open, there's not really a break-in, entry, and trespassing in the same way. We'd ask that probably cause them to be found for the purpose.
Anything from the state?
Your Honor, I would point out that the victim in this case told law enforcement that he didn't give the defendant permission to enter into the bedroom. It was a shared residence, but the defendant was not authorized or licensed to be in the victim's bedroom, which is where the theft occurred. There is enough here to support this for probable cause purposes, a finding of probable cause on the burglary, as it was an entry into the bedroom.
I'm going to find probable cause, but I'll adjust the bond. I mean, I think it's probably a fair way. Sir, just real quick, I read the affidavit. I even think it used the term like Airbnb was the term that was used in that affidavit. I equate this to you're invited to go into a Circle K, walk around all you want, select items. You just can't walk behind the counter or back in the supply room because those are off limits. That's kind of the same gist here as you're certainly, I realize you didn't break into the neighbor's home or something like that is the allegation. That's not what's being accused of. So I'm finding probable cause because what's needed for today's purposes is a low standard. What's needed to convict you at trial is much higher. So under that lower standard, I'm going to find probable cause for burglary of an occupied structure. I'll set your bond at 7,500. Set your bond on the petty theft at 250. Have a great day, sir.
You appointed PD?
I did. I'll appoint the public defender. Yeah. Have a nice day, sir. Emmett Dorsey. Mr. Dorsey, you're charged with domestic violence, aggravated assault, domestic violence, battery, tampering in a felony third-degree proceeding, and grand theft of property greater than $750. Do you want me to appoint the public defender?
Yes, sir.
All right, I'll go ahead and appoint that office to represent you. Yep. And there's a fifth thing, a fugitive, that didn't even make it to me. And sir, I wasn't aware, but you have a warrant out of another state. We give that phrase, we use the phrase fugitive from justice. Different kind of a phrase than if you were wanted out of another county. I've had a lot of those today, but yours is another state. So that's why we use the phrase fugitive from justice. Mr. Dorsey, I'll appoint the public defender on the 4 local charges. In fact, if you want the public defender on the fugitive from Missouri, I'll appoint them on that to help you with the extradition. Do you want them on all 5?
Yeah, that's fine.
Okay, I'll appoint them for all 5. Let me just jog my memory again on specific facts here. Yeah. All right, sir. Having reviewed the affidavit here again from the Winter Haven Police Department, I'm finding probable cause. Going to set your bond on the domestic violence ag assault at 10,000. On the domestic violence battery, I'm going to set your bond at 5,000. On the tampering, which is a second-degree felony, I'll set it at 10,000. And on the grand theft, I'll set it at 5,000. Those bonds are all going to be conditions of pretrial release. If you're able to post those bonds, you must immediately check in with pretrial release. I want you to call that office daily. You have all the standard conditions of pretrial plus the following special conditions. 16, 17, and 18, which I've given to a lot of other people today, which is no weapons or firearms or ammunition can be possessed, no intentional contact with the victim, stay 500 feet away from the victim, her home, her vehicles, where she works or where she goes to school. Since you lived there with her in the Winter Haven area, you get to go back one time with the police to get your stuff within 48 hours of getting out of jail, but they have to accompany you. And because there's been an alleged death threat, and the allegation is you held a knife to her throat and threatened to kill her, I'm going to order that if you post bond, that you're not to be released from the Polk County Jail until you've been outfitted or equipped with a GPS monitor. I'm not going to put you on house arrest, but I really want to know where you go at all times. Specifically, I want to make sure you don't go within 500 feet of the victim. And that's the best way that I can ensure that you don't. Have a nice day, sir.
Right here.
Yes, and no bond on the fugitive from justice, if I didn't say it. Andrew Doxey. Mr. Doxey, you're charged with domestic battery. Do you want the public defender?
Yes.
I'll appoint them to represent you, sir. I've looked over the paperwork, finding probable cause, taking everything into consideration. I'm setting your bond at $2,000, making it a condition of pretrial release. You post that bond, immediately check in with pretrial, sign up in person, call them on Fridays. All the standard conditions plus special conditions, 16, 17, 18. No weapons or firearms or ammunition can be possessed. No intentional contact with the victim. Stay 500 feet away from the victim as well as their home, vehicle, where they work or where they go to school. And because you resided with the victim prior to arrest, you get to go back there one time within 48 hours of your release, accompanied by the police to retrieve your essential items like medicine and clothing. Have a great day, sir.
You too. What was the bond?
2,000. Yeah. Next up, we have John Edward Grant, who's been charged with possession of cannabis, possession of paraphernalia, resisting without violence, and operating a motor vehicle with a suspended license with knowledge. They allege that it's a third or subsequent offense, so that driving while license suspended is a felony. Sir, do you want the public defender?
Yeah.
I'll appoint them. After reviewing the documents, finding probable cause, 1,000 on the paraphernalia, 1,000 on the resisting, 1,000 on the cannabis, but the big one is the felony, driving while license suspended, that's 5,000. Have a great day, sir. Devin Hannah is charged with possession of meth and possession of paraphernalia. Sir, do you want the public defender?
Sure, yes, sir.
I'll go ahead and appoint them. I've looked over your paperwork, finding probable cause. Your bond on the felony, the meth, is 5,000. The bond on the paraphernalia is a misdemeanor, it's 1,000. Have a great day, sir. William Holmes is charged with battery on a person 65 years of age or older and criminal mischief, damage to a property less than $200. Sir, do you want the public defender?
Sure.
I'll appoint them to represent you. I've looked over your paperwork. I find probable cause for the charges, setting your bond at 250 on the criminal mischief, but 5,000 on the battery on a person 65 years of age or older. Just so you're aware, that is a felony because of the age of the alleged victim. If you post those bonds, you must immediately check in with pretrial, sign up in person, calling them on Fridays, all the standard conditions plus the following special conditions. You're not allowed to use, possess, or carry firearms, weapons, ammunition, or knives. You're not allowed to have any intentional contact with the listed victim. This means directly, indirectly, or through a third party. Stay 500 feet away from the victim as well as the victim's home, vehicles, place of employment, or school. Have a great day, sir. Bryant Empson is charged with possession of cannabis, possession of paraphernalia, and the big one is possession of cannabis resin. That resin is a felony. Sir, do you want the public defender?
Yes, sir.
I'll appoint that office to represent you. Having found probable cause, I'm setting your bond on the two misdemeanors at 1,000. That's on the cannabis and paraphernalia. But of course, the big one's the resin of cannabis. It's 5,000. Have a great day, sir. 5,000 cash or surety. Ricardo Jacques is charged with driving while license suspended under a permanent revocation. Sir, do you want the public defender appointed to represent you?
Yes, sir.
I'll appoint that office to represent you. Sir, I've looked over your paperwork, finding probable cause. Real quick, he has open summonses. It looks like there's some CTs there. What are those charges for? Driving while license suspended. So open cases, is it the 1897? Is it the 9632? He's got 2 open driving while license suspended. He's picked up a third where they're alleging it to be a felony based upon priors. I can't parker him because they're notice to appears, but I can certainly increase his bond, which is what I'm going to do. Sir, finding probable cause, going to set your bond at $10,000 cash or surety. Have a great day. Javaris Jenkins. Mr. Jenkins, you're charged with burglary of an unoccupied conveyance as well as petty theft. Do you want the public defender?
Yeah.
I'll appoint them to represent you. Having reviewed the paperwork, finding probable cause, your bond is 5,000 on the burglary, 1,000 on the petty theft. Going to make those bonds conditions of pretrial release. If you post those bonds, immediately check in with pretrial, sign up in person, calling them on Fridays. You have all the standard conditions plus special conditions 16, 17, and 18, which is no weapons, firearms, or ammunition to be possessed. No intentional contact with the victim. Stay 500 feet away from the victim as well as their home, vehicles, place of employment, and school. And because you, before I let you go back there, I want to double check that you had the same address. Looking at the Lake Wells affidavit. Yeah. I remember now. That's what threw me a little bit. Yeah, so they charged you with burglary. And the burglary has to do with a vehicle. Yeah. So, yes, sir. Because you resided in that home prior to being arrested, you get to go back to that home one time to get your stuff. That has to take place within 48 hours of getting out of jail, and you have to take the police along with you to do that. Have a great day, sir. Nicholas Knopf. Sir, you're charged with failing to appear for court pretrial conference on a charge of stalking. I bet he probably has an attorney already. It's okay. All right, sir, do you want the public defender appointed to represent you?
Your Honor, I was already denied that. This case has been going on since August of last year. I'm hoping I can get a bond so I can get out to finish dealing with this case. I've never missed a court date with this all going on. So I'm hoping to be able to get a bond so I can get out today.
Well, sir, I don't want to give you a long answer, longer than you want to hear, but I wasn't the judge that issued this capias, and a capias is a fancy way of saying a bench warrant. Instead of a judge signing something, he just utters some words and the clerk do the paperwork. Right. So in your case, this is a bench warrant called a capias. Judge Gibson was the judge presiding. She issued the capias and it's for no bond. Now,
right, I seen her yesterday. I filed a motion to try to dismiss it all. And I went and seen her yesterday, and unfortunately she denied it, but wouldn't that change the outcome since I made it to her?
Well, it looks like you got arrested yesterday. So maybe they took you into custody based upon the warrant. So I wasn't there, so I don't know. I can just tell you that here's her capias and here's where they stamped it, wrote the date in it, where the deputy took you into custody. So if you don't, back to my original question that got us on this track was, I was going to offer the public defender. You said you've been already determined that you don't entitle. So I won't, if you don't want them, you don't want them. Now your situation.
This is my next concern. If I'm not able to make bond, then I will need a public defender because I'm fixing to lose my job. I'm fixing to lose everything I got going on right now.
All right. And so you're kind of right on the same thought process as me. If you're in jail, you're not making any money unless you're just independently wealthy. I would provisionally appoint the public defender, but provisionally means, you got to go fill out the application. And if you do have a job, then you're going to probably, they're going to say, we're not going to be able to stay on the case. I don't have my crystal ball, so I don't know how long you're going to stay in jail. Mr. Mathis, you might have a different view of that. I mean, I always err on the side of
For a 5-day hearing.
Speaking?
Want to set him for a 5-day?
Yeah, well, he is. I'm going to get it.
You should be able to address your bond in 5 days with the judge, sir.
Okay. What day would that be?
There, I can tell you that you're going to go see Judge Gibson or whatever judge is handling this case on the 17th. That's Tuesday. So if you've lost your job by then and you know about it, odds are you're probably going to qualify. But if you find out, you've learned between now and then that, your job's waiting for you, then you probably won't qualify. You don't want to waste the $50 application. So do you just want to hold tight and address it with the judge on Tuesday?
That's this Tuesday coming up, sir?
It is, yeah, the 17th. Today's the 13th.
Yeah, I guess that's fine.
Yeah, you can always, like I said, I've been saying it all day. If you go see the judge on Tuesday, you can ask for the public defender then based upon what you've learned about your job. And at any point, if your situation changes, like hours get cut or your house get repoed or you lose your job, you can always ask for the public defender as your circumstances change. Right. Okay. So I'm going to find probable cause because I told you the whole history of the warrant, the capias. I'm going to hold you no bond. 5-day hearing is March the 17th at 8:30. Have a great day, sir. Next up, we have Dwayne Lewis is charged with a warrantless VOP. You want to waive the reading? Yeah. Sir, do you want the public defender on this VOP?
No, sir. I got a private attorney, sir.
Okay, fair enough. If you change your mind, you can always ask at any time moving forward. Sir, I'm looking at, looks like it's, you must have been supervised out of Pinellas County. I'm looking at that paperwork from that county, finding probable cause, going to hold you no bond, and you'll go see the circuit judge here on April the 2nd.
Yes, sir.
April the 7th. Have a great day, sir.
All right, sir.
Moving right along, Charles Luster is charged with possession of methamphetamine, possession of drug paraphernalia. Sir, do you want the public defender?
Yes, sir.
I'll appoint them. Having reviewed the paperwork, finding probable cause, your bond, and just so you know, I'm taking into consideration that you have an open case, a misdemeanor, that's not a parkerable offense, so I can't hold you no bond. But what I am going to do is elevate your bonds as a result of that. Your bond on the meth is going to be $7,500. Your bond on the paraphernalia is $2,500. Have a great day, sir. Terrence Marcus is charged with a VOP. What put him on probation was domestic battery. Do you want the public defender?
Yes, sir.
Appoint them to represent you. I'm looking at Judge Harb's warrant, finding probable cause. He wants you held no bond. You'll go see him on April 7th. Have a great one. LeVar Eric Mayfield is charged with driving while license suspended, a third or subsequent offense, making this a felony. Do you want the public defender?
Yes, sir.
He's on active probation, huh? I missed that. This is Mr. Mayfield. Yeah, active probation, 4614. That's what I missed. Ms. Dawes, will you do me a favor?
Yes, sir.
CF 24-4614. Would you just see if he was put on probation, and if anything shows that that probation has been terminated, or
What's the?
CF 24-4614.
That's a different name. I don't know what name.
LeVar Mayfield.
Is this who we're on?
Yeah,
Oh, then I'm wrong. Okay. That's
LeVar Mayfield.
fine.
So, sir, while she's looking that up, do you want the public defender appointed to represent you on the charge you're here for?
Yes, sir.
All right, I'll go ahead and appoint that office to represent you. I have looked over your paperwork, finding probable cause, setting your bond at the standard for this felony, which is $5,000. Now, having found probable cause, and Ms. Dawes confirmed for me that you are on probation, I am going to take you into custody on what we call an instanter warrant, hold you no bond, appoint the public defender for your VOP, and of course, hold you no bond pending going to see the judge. It looks like you're going to go see the judge on all this for together. It would go together.
Yes, sir.
The bond on this one is $5,000 because it's a an F3 and it's charged as a felony. So
Yes, sir. It'll be heard in any case.
so I'll do it in instanter and hold him no bond and appoint the public defender. Have a great day, sir. Matthew Minardi is here, having been charged with 3 VOPs. All right. Mr. Minardi, do you want the public defender?
Yes, sir.
Appoint them to represent you. I'm looking at Judge Harb's warrant, finding probable cause, holding you no bond, and you'll go see him. I think it's on the 4/7.
Okay.
All right?
Yes.
Yep, 4/7 it is. Have a great day, sir.
Yes, sir.
Jerry Mullenix is charged with possession of meth, possession of paraphernalia. Sir, do you want the public defender?
Yes.
I'll appoint him. Finding probable cause for these 2 charges. On the meth, it's $5,000. On the paraphernalia, it's $1,000. Have a great day, sir.
I'm here, too.
Eduardo Newkirk is charged with a VOP. What put him on probation was attempted possession of a firearm by a convicted felon. Do you want the public defender?
Yes, sir.
I want him to represent you. I'm looking at a BOP warrant signed by Judge Harb about a week ago, finding probable cause, going to hold you no bond, and we'll send you to see him on April the 7th. Have a
Yes, sir.
great day.
Thank you.
That brings us to Mason John Noss, who's charged with petty theft. Mr. Noss, do you want me to appoint the public defender?
Yes, sir.
The allegation is the theft was greater than 100, but less than 650. So that's a first degree misdemeanor. I'll appoint the public defender. I've looked over the paperwork that's been provided, finding probable cause. I'm going to set your bond at $1,000. Make it a condition of pretrial release. If you're able to post that bond, check in with pretrial, sign up in person, call them on Fridays, all the standard conditions, plus special conditions 17 and 21. So you're not allowed to have any contact with any Target store, not just the one that they accuse you of stealing from, but any Target store, whether it's here in Polk County or anywhere else. Have a great day, sir. Gabriel Ivan Ortiz Gonzalez is charged with domestic violence battery. Do you want the public defender?
Sure.
I'll appoint that office to represent you. Sir, I've looked over your paperwork. It's from the sheriff, finding probable cause. Taking everything into consideration, I'm going to set your bond at $2,000. I'm going to make that bond a condition of pretrial release. If you post that $2,000 bond, you must be supervised by pretrial. So you'll need to sign up in person with them immediately after getting out of jail, calling them on Fridays, all the standard conditions plus special conditions 16, 17, and 18, which you've heard already, which is you can't possess weapons, firearms, or ammunition. You can't have any intentional contact with the victim. Stay 500 feet away from the victim, as well as his home, his vehicles, where he works, where he goes to school. Because you resided with him in the same home before being arrested, you get to go back there one time to get your essential stuff, but you have to do it within 48 hours of getting out of jail, and you have to do it with the police tagging along. Have a great day, sir. Again? Right. Nathan Perez Sosa is charged with a VOP. What put him on probation was there's actually 1, 2, 3, 4, 5, 6 different VOPs. Things that put you on probation are criminal mischief, burglary, grand theft, burglary. Sir, do you want the public defender?
No, sir, I have a paid attorney.
Fair enough. If you change your mind, you can always ask at a later date. Looking at Judge Harb's, sure. Did I miss something? Yeah, just
Okay, congratulations, right?
the sheriff's paperwork. It starts off numbering 2 through 7. You have 1 through 7. So am I missing, is the sheriff document missing one? So you believe there's, is it? Yeah, so
It says attempted on this charge.
9940.
Yeah, so I think it's the attempted burglary.
Yeah, the one at the bottom,
Yeah.
which is a different case number. So, sir, there's 7 things that you're on probation for. You have a private attorney, you said. Finding probable cause, looking at Judge Harb's warrant, he signed it about a year ago, almost a year ago. Going to hold you no bond, and I'll send you to see him. You'll go see him on, is that date still good? March the 16th? All right, yeah, you'll go see Judge Harb early next week. Have a great day. That brings us to Seamus Dante Reynolds. Seamus Reynolds is charged with resisting without violence. Mr. Reynolds, you want the public defender?
I'm trying to bond out, sir, much as fast as I can. I don't know. I don't even know.
All right, if you want him, I'll appoint him. If you don't say, yeah, Judge, I won't appoint him, and you can always think about what you do next.
All right.
All right, so if you change your mind and want the public defender, just let me know before we call it a day here or ask for the public defender at any future court date. Sir, I've looked over the sheriff's affidavit, finding probable cause, setting your bond at $1,000. Have a great day.
Thank you, sir.
Yeah. And he didn't want the public defenders. He just said he didn't know for sure, so I told him to think about it, let us know. James Ricketts is charged with possession of cannabis, possession of paraphernalia, and the big one is possession of cannabis resin. That's the felony. Sir, do you want the public defender?
Yes, sir.
I'll appoint them to represent you. I've looked over the sheriff's affidavit, finding probable cause. You get all the standard bonds, which is 1,000 on the cannabis, 1,000 on the paraphernalia, 5,000 on the felony, the resin. Have a great day, sir. Christopher Jesus Rodriguez is charged with trespassing. Do you want the public defender?
Yes, sir.
I'll appoint them to represent you. I've looked over the Winter Haven PD affidavit, finding probable cause. Your bond is $250. Have a great day.
All right, thank you.
Reed Eric Carl Roseberg.
Sir.
Sir, you're charged with driving with an expired driver's license more than 6 months and resisting without violence. Do you want the public defender?
Yes, sir. And stating, I'd like to state, and I apologize, I had no chance to get over there to get this accomplished.
I'll appoint the public defender. Going to find probable cause from the affidavit I have in front of me, setting your bond at 1,000 on the resisting without, 250 on the driving with a driver's license expired greater than 6 months. Have a great day, sir.
Okay, thank you.
You bet. That brings us to, you already did Mr. Stewart, I believe. So we are up to Daniel Ware. Daniel Ware. Mr. Ware, you're charged with possession of an open container and failure to appear for court on a charge of possession of an open container. Sir, you're not entitled to the public defender, but I can give you a court-appointed attorney if you want one.
Yes, sir.
All right, I'll appoint, I'll do an order to do Ms. Cheatwood or some other attorney on Mr. Ware for both of these charges. Mr. Ware, I'm looking at a capias from Judge Flynn out there in Lakeland, and I'm looking at an affidavit from the Lakeland PD finding probable cause for both. Judge Flynn set your bond at $250, so that's not a parkerable offense, so you'll be at $250. On the new charge, taking into consideration you have an open charge for the same thing that allegedly you missed court for, and when they got you for the capias, you had another open container. I'm going to bump your bond up to $750. So add them up, it's a total of $1,000. Have a great day, sir.
Thank you.
Randall Allen Whitaker has several VOPs, 1, 2, 3, 4, 5, 6, 7 VOPs. Sir, do you want the public defender?
Yes, sir.
I'll appoint him. Looking over your paperwork, I have Judge Harb's warrant right here beside me. Finding probable cause. He signed it the 10th of March, so 3 days ago. Finding probable cause. We'll send you to see him on April 7. Have a great day. Robert William Oski. William Oski.
Williamowski, yes, sir.
Apologize, sir. Williamowski. Sir, you're charged with driving under the influence. There is an allegation that you have a prior, and then you are charged with refusing to submit to a breath alcohol test. Do you want me to appoint the public defender, or are you going to hire one?
I haven't hired one yet, but I've been looking.
Okay, you tell me, do you want to keep looking and think about your options, or me appoint the public defender provisionally right now?
Provisionally, it's not bad.
Okay.
Please, sir. Please, sir.
Not a problem. The way I look at it, you're in jail, you're not making any money, and I don't know when you're going to be getting out unless I'm the one that lets you out.
Please.
So you're going to have to do it. Yeah, you're going to have to
beg for mercy.
fill out an application, sir, with the public defenders, but I'll provisionally appoint the public defender. Having reviewed the paperwork from the FHP, I find probable cause for the 2 new charges, also factoring in your prior DUI. It's got some age on it. It's from 1988. What I'll do is I'll set your bond, having found probable cause, at 1,000 on the refusal and 2,000 on the DUI, a second. I'm going to make it a condition of pretrial release. So if you're able to post that bond, you must immediately check in with pretrial, sign up in person, calling them on Fridays. You have all the standard conditions plus the following special conditions. You're not allowed to be in possession of, nor can you consume any alcohol. You can't go to any bars, nightclubs, or lounges. You'll be subject to random urinalysis that includes breath. I'm going to put you on a curfew, sir. You got to be in your approved residence between 10 p.m. and 6 a.m., okay? Can't be out running the streets at times of the night when a lot of people are, well, at that time of night where people are getting out of the bars and stuff. So you got to be in your approved residence from 10 p to 6 a. Have a great day, sir.
Thank you, sir.
You got Brandon Williams. Mr. Williams, you're charged with a BOP for domestic battery. Do you want the public defender?
Yes, sir.
I'll appoint the public defender. Looking at Judge Kaler's warrant, finding probable cause, she wants you held no bond. We'll hold you no bond. You'll go see her April 28th. Take it.
Should be actually sooner. It'll be on March 23rd.
Yes, sir, Your Honor.
There it is.
Okay, so we're going to send you, we moved your court date up a little bit. Your court date's now March the 23rd. Have a great day.
Your Honor, I have a quick question, real quick. Does it make a difference that my wife actually reached out to the state attorney to give her proof of my completed community service hours and proof that I reached out to my probation officer on the missed day?
Well, I guess what you're saying is that you failed the allegations that the judge was looking at when she signed the warrant. There are two of them. One says you failed to report for the month of February. The other is that you owe 50 hours of community service. So that's what she looked at when she made the decision to sign a warrant for no bond. I don't want to go back and Monday morning quarterback her. That was her decision. She's your judge.
Yes, sir.
So as far as making it a difference, you know, at the end of the day, the state has to prove that you didn't do these things in the affidavit. I don't know if it's true or not. That's why we have hearings for the state to try to prove it.
Yes,
Certainly, if you have proof that these things were done timely, well, certainly you can talk to your lawyer and y'all can present a potential defense if you choose to. Okay.
Yes, sir.
Have a great day, sir.
Thank you, Your Honor.
You bet. And next up is Joshua Wright. Mr. Wright, you're charged with 4 things: grand theft, tampering with a witness, unarmed burglary of a dwelling, domestic violence, battery by strangulation. Do you want me to appoint the public defender?
Yes, sir.
I'll appoint that office to represent you. Sir, I've looked over this warrant that I'm looking at here that looks like Judge Ward, he's a circuit judge that works out of Highlands County, has already signed. He signed it in early February, excuse me. Would the state like to be heard on bonds?
Yes, Your Honor.
Go right ahead.
Can I approach, Your Honor?
Sure.
Your Honor, this is a motion for pretrial detention as it relates to the burglary of the dwelling charge. Should Your Honor find this motion to be legally and facially sufficient, state would request a pretrial detention hearing be set on Thursday, March 19th at 1 p.m. on the AT docket.
So just to be clear, this is pursuant to Florida Rules of Criminal Procedure and the statutes that I outlined earlier from your other motions. Burglary of a dwelling is an enumerated offense.
Yes, Your Honor.
Okay. Anything from the defense?
Burglary, like unarmed burglary, not occupied dwelling is an enumerated offense, not armed burglary, not occupied dwelling. I think that's
Well, what he's charged with is just a burglary of a dwelling. So, well.
I've never really into this, what it is.
All right, as far as if I hold him on the burglary, you may just let the circuit judge deal with all the, I'm happy to do either, wanted to give you the option. Sir, I'm looking at a 2-page document that's entitled Motion for Pretrial Detention. I'm finding on it from its face that it's legally sufficient. I'm going to hand it to the clerk, and as a result of that, going to hold you no bond on the burglary of a dwelling. Now, candidly, between you and me, entitled to bonds on the other ones, but instead of giving you bonds now, me and the attorneys have talked. You're not going anywhere as long as that no bonds on the burglary of a dwelling. Probably makes a lot of sense to let the judge that you see during your hearing where the state has to present evidence and your attorney will have time to prepare and make an appropriate argument. Might as well let that judge deal with all 4 charges. So that's what I'll do. I'll hold them all no bond, even though you're entitled to a bond on the 3 that aren't the burglary of a dwelling, but making a decision that that judge should deal with all of them. We'll send this to see the A2 judge on April the 14th at March 19th. Oh, I'm sorry, I was looking at it as arraignment. My apologies. Your arraignment is April 14th. Your A2 pretrial motion is going to be on March the 19th. So you'll go handle the no bond next week. Have a great day, sir. And I think we're up to Cordero Harris. Cordero Harris.
Yes.
He was, yeah. It's
I don't know that we got paperwork.
Cordero Harris is just a trespass, failed to appear for an arraignment. It's a Lakeland, Judge Flynn, if you want to see what I have. Yeah, Mr. Harris, you're charged with trespass out of our Lakeland courthouse. Do you want me to appoint the public defender?
Yeah.
I'll appoint him. Looking at Judge Flynn's capias from just 2 days ago, finding probable cause, setting your bond at $1,000. Have a great day, sir. Looks like your court date is April 2.
Yes.
And this last gentleman, I've run out of paperwork. Who is this gentleman?
That's the first one I asked you about earlier, Acosta Vasquez Eugenio. You said you had already done him?
You asked me had I done Aguiar.
Yeah.
And we did
Not
Aguiar.
Costa,
Yeah, you never asked about.
not Costa?
You said Aguilar. Aguilar. So,
That was one we did, but okay. Anyway, he
Yeah,
hasn't.
Yeah, you're absolutely right. I have not done Acosta. Candidly, he was one that showed up as SPC. And I wasn't sure where he was, but I probably should have called him nonetheless. So I apologize about that, Mr. Acosta. So Eugenio Kaleem Acosta Vasquez.
yes.
Sir, you have a warrant from another jurisdiction. It's Brevard County. Charges are fleeing to elude and attaching a tag not assigned. It looks like you had Judge Silverman there. I cannot appoint a public defender here because it's a different public defender's office, different circuit, different county far away. But you can hire a lawyer if you want, or you can wait to see the judge when you get back over to Brevard. What is that, Daytona Beach area over there? Get back over there and you can ask for the public defender if you want them. I'm looking at the paperwork, finding probable cause. Looks like Judge Silverman set your bond on the fleeing to elude at $25,000. He set your bond on the attaching tag at $1,000. So you have bonds, you are bondable. If for some reason you haven't bonded out and they haven't come to get you in a week, I'm not saying the judge is going to release you because I don't know what that judge will do, but at the very least, I'm going to bring you back to see a judge next Friday so you and that judge can discuss what needs to take place, okay? But
Yeah, I'm pretty sure the bond is set already. I'm just waiting.
yeah, it's 25 and 1, so 26 total. Have a nice day, sir.
Thank you.
Thank you, deputies. Y'all have a great rest of your day and a great weekend. Yes.